Good morning to all of you. Welcome to Legal Matters by Sai Babu Sunkara. While dealing with the law of torts, I have described in detail regarding the contributory negligence. Negligence, breach of duty of care, contributory negligence, two persons, they contribute. The plaintiff as well as the defendant, they contribute. And composite negligence, where the defendants are two or three. If two or three are negligent, then it is called composite negligence. Please remember, contributory negligence means not only the defendant and the plaintiff also contributed something to cause the accident. Had he taken sufficient precautions or had he diverted the vehicle to the other side, this incident would not have happened. So he is also negligent. This is what contributory negligence. But yesterday, the Honorable Supreme Court of course, on 6th 10, the Honorable Supreme Court of India clearly held that when some person takes some extraordinary precautions to avert the collision, then he cannot come under the ambit of the so-called contributory negligence. Right. This is envisaged by the two judges bench, Justice Hemant Gupta and Justice V. Ramasubramaniam of the Supreme Court of India, in the case of K.Anusha versus Regional Manager Shriram General Insurance, Shriram General Insurance Company Limited, 2021. You can see this case in Live Law LL 2021 SC 571. This judgment was given on 6th October 2021. So please remember, failure to take some extra precautions, failure to take some extraordinary precautions, it cannot come under the contributory negligence. Right. So now, if we go into the details of the incident proper, I think you will have a clear knowledge, clear picture about the incident and the so-called contributory negligence also. Right. So here it happened in Karnataka state. The High Court of Karnataka has given 17 lakhs or so as compensation to the victim. What happened is on September 10 to 2011, February 10th, 2011, Anushka's husband, he was the deceased, Anushka's husband was traveling in a car driven by the driver. Incidentally, while averting a major accident, he has swerved the vehicle to the left side and actually this has hit a parked lorry from behind. The lorry suddenly stopped. The problem is the lorry stopped there suddenly and without any light signals and things, this man went and hit him. Now, while awarding the compensation, the tribunal as well as the High Court held that the driver of the car is also contributory negligence. Actually, Anushka and others, Anushka and her two sons, they filed a case of compensation against Shriram Life Insurance Company. And they filed in the High Court. Of course, the High Court was also satisfied. They given some compensation of 17 lakhs or so. But the tribunal, that is MEA tribunal or High Court, they opined that why such less amount? Actually, they filed for 54 lakhs. Why that less amount is because there is contributory negligence on the part of the driver. That means he has not taken extra precautions. Only two things. He has not, had he followed the traffic rules, had he seen the vehicle in front, he could have averted the accident. Therefore, since he did not avert the accident, he is also liable, contributory negligence. This is observation by the High Court. Of course, the insurance company also felt happy. 17 lakhs is peanuts for them. And the appellant, that is Anushka, she has filed an appeal before the Supreme Court against the lesser amount of compensation ordered by the High Court. The main point is regarding the contributory negligence. So, please remember, to establish the contributory negligence, number one, some act or omission which materially contributed to the accident has to be proved. Contributed to the accident or damage has to be proved. And it has to be attributed to the so-called plaintiff. Normally, defendant will allege contributory negligence on the plaintiff. Right? So, the High Court noted that the driver of the car should have been vigilant and followed the traffic rules and the accident would have been averted. But please remember, when the Supreme Court produced the document, there is no evidence to say that the accused was not driving the vehicle in a moderate speed. That means he was not driving the vehicle in a, there is no evidence to say that he was driving in a rash or negligent manner. No evidence. Second point, there is no evidence that he did not follow the traffic rules. He was not challaned and no traffic constable was also. So that means the observations of the High Court are riddled with so many contradictions. Of course, here the Supreme Court referred to the famous case Astley versus Astley, A-S-T-L-E-Y, versus Austrust, A-U-S-T-R-U-S-T, Austrust. It is an Australian case, limited 1999. Actually, this is a case regarding the contributory negligence on the part of the auditor. This trust, they have filed a case against the auditor also. Auditor said he did not pay any contributory negligence like that. So in that connection, the Honorable High Court of Australia, they held that, so by negligence, if any person puts the other in a dangerous situation which compels the other person to act quickly to extricate himself. So if one person, if the defendant put a person in a dangerous position, and if the plaintiff does some act to extricate himself from the outside, then it cannot be contributory negligence. Here, now if you compare it or if you apply the theory to our case, the driver actually, in order to avert the major accident, he has turned to the roadside and actually he wanted to park it there. Incidentally, some lorry suddenly came and stopped without any signals, due to which it hit the lorry from behind and the deceased Anushka's husband died. Right. Now, 3 points the Supreme Court observed. Please remember. Number 1, the vehicle was not at a parking place. So that means the lorry was not parked in the parking slot. Just haphazardly he parked it. Second, actually the lorry should have been parked on the extreme left side of the road, but it is not so. And the danger lights or signals of parking were not at all exhibited by the lorry. And the third point is the incident occurred around 4:30 a.m. where the lighting will be very poor. So therefore, the view of the High Court is very much wrong, with a full of contradictions. Ultimately, the compensation was raised from 17 lakhs to 58 lakhs. So very good judgment. So enhancement. So they are all the multiplier theory, all these things they have been discussed. Since it is more than 5 minutes, I'm not going into details of the same. But anyway, enhanced to 58 lakhs to the satisfaction of Mrs. Anusha. So good judgment regarding the contributory negligence. So if you take some precautions to avoid a major accident, if some accident happens, then it cannot be called as contributory negligence. It can be at the most called as mistake of fact. That's all. Right? Thank you very much.